Hi everyone, this is John Gerardi, the director at Right to Life of Central California, and this is the Right to Life classroom, where we break down and explain difficult pro-life concepts in a way that's simple and easy to digest. Today we're going to talk about the big Supreme Court decision. The Supreme Court kept in place a Texas law banning abortion after 6 weeks of pregnancy. What the state of Texas did was ban abortions after the point that fetal heartbeat can be detected. This is somewhere around the 6-week point. Around 6 weeks, cardiac activity can be detected, which is basically the beginnings of the heart beating. Texas has decided that they are going to extend protections to children in that situation. Now, a lot of states have passed fetal heartbeat laws. States like Louisiana, Missouri, Ohio, but all of these states had their laws struck down by the courts. Why has the Texas law been allowed to stay in place? All of those other states imposed criminal penalties on abortions after 6 weeks. Because the states enforced criminal laws, Planned Parenthood and other abortion activists were able to sue those states in court and get the courts to issue an order to those states telling them to stop enforcing the law. What Texas did differently was outsource the enforcement of the law. Instead of having the state enforce it through criminal penalties, what Texas did with their heartbeat ban is create a private right of action, basically allowing individuals like you and me to sue abortion doctors if they do abortions. When abortion activists tried to sue the state of Texas in the courts and to prevent them from enforcing the law, Texas was able to say, well, we aren't enforcing the law at all. We've just created a private right of action. We've allowed our citizens to sue abortion doctors for doing abortions. Because basically, abortion activists sued the wrong people, the Supreme Court said, well, we cannot prevent someone who is not a defendant in this case from acting. You need to sue the right people. As a result, Texas's abortion statute is going into effect, and abortion clinics throughout Texas are stopping their abortion procedures. This could result in hundreds of children not being aborted in Texas every day, and possibly as many as 4,000 children a year surviving abortion in the state of Texas. This is an incredible milestone. Never in the United States since the 1973 Roe v. Wade decision has any state been able to have on its books and enforceable a law prohibiting abortion. Will this stand? It's unclear. Eventually, at some point, a private citizen will sue an abortion doctor for performing an abortion. The Texas courts will hear it, and the ultimate fate of this Texas statute, I believe, will be decided at the same time as the fate of Roe v. Wade and Planned Parenthood versus Casey. As many of you know, the Supreme Court in this judicial term is going to hear a case called Dobbs v. Jackson Women's Health Organization. We had a number of videos explaining this case and what it could do in the Right to Life classroom. Basically, this case will decide the question, are we going to uphold Roe v. Wade or not? Are we going to uphold its successor, Planned Parenthood versus Casey, or not? Can states ban abortion for any duration of the pregnancy, or can't they? Is abortion a constitutionally protected right? Or is it something cooked up by 7 Supreme Court justices in 1973? When the court decides the Dobbs case and settles the final fate of Planned Parenthood versus Casey and Roe v. Wade, that's when we will know whether the Texas abortion law will stay in effect for good. For Right to Life of Central California, I'm John Gerardi.